Appellant and Miss
I think it's Miss Milligan.
Scarlett Milligan appears for the Respondent, and Miss Kate Longson appears for the
Interested party.
interested party. Although this is according to the order of Mr. Lord Justice Stuart-Smith, is a rolled-up hearing in which first stage will be for your lordship to determine whether permission is granted, and if so, we shall proceed to make our submissions on the substantive issues.
Well, thank you very much, Mr. Alani. Can I indicate that we've had an opportunity to read extensively into this case? We have the great benefit of having Lord Justice Stuart-Smith as part of the Constitution, and his, if I may say so, his extremely helpful order when listing this case, which has saved us all a great deal of time. We're also very grateful to you, Mr. Alani, for the documents you have filed, which, if I may say so, are extremely clear and helpful and set out the arguments very well, if I may say so. And we're also grateful to Miss Milligan, who's coming quite late and has adopted what we think is a sensible and realistic approach to this. We're very conscious of that we're here to determine an application for permission to appeal, and if permission granted, appeal against the deputy judge's order, and not dealing with anything involving orders made in the county court, at least not directly. So we shall need some help from all of you, I think, on exactly what you think we should do, particularly if we're minded to grant permission and allow the appeal.
I'm grateful for your generosity, my lord. I would like to outline what I think is really in dispute in the hearing, because I'm very grateful for learned counsel who had filed a very, very sensible written statement on behalf of the respondent, taking a neutral position and at the same time identifying the legal issues on which we do not differ very much. I think the only contention is whether the hearing that came before the Deputy High Court judge was a hearing to consider a nullity or not. Because if we can establish, as our respectful submission is, if we can establish that what came before the Deputy High Court judge is a nullity, then the proceedings before him was a nullity, and the outcome would be a nullity. And we are back to where we started, whether we like it or not, at event one.
What strikes me, at least, and I think my colleagues as well, is that the standout, well, there are many things that went wrong in this case, Mr. Alani. I think we can all agree with that. And no doubt we'll touch on others in a moment. But the standout, glaring omission here is that your client applied to set aside what's been called the Avant 1 order, and that, for whatever reason, that never happened, and it's never been determined. And it may well be that one thing that should happen is that should happen before anything else, or before we get any further, or certainly very soon. So that seems to us to be a clear point at the moment, or for my part it does.
Well, we don't seek more than that, my lord. All we're saying is that since event one and the application to set it aside, which still stands, with counsel for the respondent accepting that, and your lordship, Lord Justice Stuart-Smith accepted that. The only legal standing issue is that application on the 3rd of March 2021 has not yet been heard, and the appellant is entitled for that to be heard.
But I think you can take it that we are all agreed. Certainly, the court is agreed. How we get it to that, whether we simply say it must happen, is a different question which we can grapple with later. Can I? Do you mind if I just? Of course. Ms. Lawson, your clients haven't served an acknowledgement of service.
Correct.
they haven't issued a application under Part 11.
Correct.
Have you served a skeleton for today?
I'm here in a noting capacity. In
Just a
reality,
noting.
is my
Well, I think we
instruction.
need to know whether you're here to make submissions, because it could affect the way that we conduct this hearing.
No, that my instructions are to
You're
follow
not here to
the
bind.
lead of the
You're not here to
respondent.
bind the CPS by anything you say. Okay. Now we welcome you as a member of the bar, but we may at some stage say some fairly trenchant things about your clients, but we won't be hearing from you about them. Okay.
The difficulty is all of this could be resolved by the CPS agreeing that everything be set aside
From Appellant 2.
except and go back to have the discharge application of Avent 1, and that's in your gift.
But it isn't.
Yes,
Sorry, not your gift.
I'm instructed as I am for this hearing. I suppose the difficulty that my client has been in to some extent is that matters ran away with themselves after the hearing before Her Honour Judge Boucher. But ultimately, the issue with Avent 1 and Avent 2, I appreciate, but I'm not instructed to say any more.
You were
about
instructed,
that.
but you were the advocate before Judge Boucher.
Correct. But at that time, what was before Judge Boucher was an application for permission to appeal Avent 2 with the inglorious history that your lordships have already alluded to.
It was still the case that you no acknowledgement of service, no application under Part 11, and no skeleton argument.
The point taken by the CPS at that hearing was that there had been no
But
service.
there wasn't any notice to the other side that you were going to be there to take that point.
The issue as regards service had been raised in correspondence
On the
as I'm
2nd of
sure you've
December,
seen,
but
on the
nothing
2nd
had been done
December
since then.
2020. But as of February 2021, the proceedings were struck out. And so it's right to say that there hadn't been any acknowledgement of service thereafter, but at that point the proceedings had been struck out. So there was, in effect, nothing to acknowledge. I appreciate then the CPS turn up at the...
I'm sorry, I'm interrupting.
No, please.
Well, but you came along to Judge Boucher and said you should refuse this application because it's never been properly served on us.
The proceedings have never been properly
Yeah.
served. But that is right, my lord. The proceedings had never been
But
properly
he
served.
had, the other side hadn't had no notice that you were going to be there to make that point.
I appreciate that might be the case. Of course, I was instructed for that hearing
Yes.
without any input prior to it. What is right and is borne out by the transcript is that Dr. Alani and I waited for some time to get on that morning, and we did have a conversation about this point outside court. So it's not right to say that I turned up for that hearing and raised the point before the learned judge for the very first time with absolutely no notice at all to the appellant. And it would have been open, of course, for the claimant, as he then was, appellant, to ask for more time, which wasn't the case. My learned friend Dr. Alani made submissions to Her Honour Judge Boucher in relation to the service point and essentially blamed the court at that point, because whilst it was acknowledged that the incorrect address for service was put on the claim form, it was suggested that...
Well, of course, you were there and we weren't there. But
Yes.
We have read the transcript.
Yes.
But I'm very conscious that you are here, and so consequently it's difficult to resist the temptation to
understand.
debate this issue with you. But you're not here as a party.
Because if the original application for judgment in default was because your clients had not served an acknowledgement of service with or without an application under Part 11, it comes back to the CPS.
Yes, except that if default judgment had been granted by District Judge Avent, it would have been vulnerable to set aside under the mandatory ground under CPR 13.2 because the proceedings had never been served validly on CPS.
Well, all these is if we had managed to achieve what I think is our primary aim, which is to facilitate a consideration of Avent 1, i.e. the set aside application.
Yes.
You would be entitled or your client should be entitled to raise the points about service in response, I suppose, providing you did so on notice in the appropriate way.
Yes, I think what would perhaps need to happen if that were the case is that the court may well need to order that the proceedings be validly served on the CPS, or otherwise it may be that those who instruct me file an acknowledgement of service in any event disputing the court's jurisdiction.
If you're not, I'm sorry, I'm interrupting you again.
No, don't please. Don't
If you're not instructed to bind the CPS, I don't think you can suggest to us that we should direct that service should be deemed to have been done or extend time for service, because your clients may not be too keen on that.
No, and let me be clear, that's not what I'm inviting you to do. I'm suggesting that it may be open to the county court if the matter is ultimately put back before the county court pursuant to the application to set aside Avent 1 to do that. And for those who instruct me, and I'm trying to be helpful, I'm not saying what will be done or what should be done. I'm simply suggesting what the options are for those who instruct me to file an acknowledgement of service disputing the court's jurisdiction and bringing within 14 days, as per CPR 11, an application for the court to declare that it has no jurisdiction to hear the claim. And indeed, I did submit to Her Honour Judge Boucher that would be an option for those who instruct me if she had remitted Avent 2, which is what she was considering, back to District Judge Avent for reconsideration of an oral hearing.
Anyway, I think the temptation here is to do what it seems to have happened elsewhere early in these proceedings, is for us to go too far. We need to be careful ensure we don't go beyond what we can do.
Yes.
That we listen courteously to submissions, but make sure we only do what we can do, and then try and set things in line for the issue, the outstanding issue to be resolved.
Yes, and let me be clear that I'm not inviting you to do anything in particular, because my instructions are to be as helpful as I can, but ultimately to sit and take a note and
Be as helpful as you can
remain
without saying anything.
neutral. Well, I've said rather a lot for somebody who wasn't planning to come
let's
and
make
say
it clear
anything.
you've been very helpful so far. Thank you very much. Now back to you, Mr. Alani.
May I make a few comments on what Learning Council just said? Firstly, the objection of the CPS on the 2nd of December 2020 was never ever served on the court. So the court has no knowledge that there is an objection from the CPS on service. The only party which was notified with such an objection was the appellant. And if you look at the record of the county court, which appears in bundle 4, there are 14 pages of it, there's no record of ever court having received a notice from the CPS on. What really happened, my lord, is that the CPS objected to the appellant on what they claimed to have been a faulty service, although the service was done effective by the court, not by the appellant, but yet they advised the appellant that he had made the wrong service, and then forgot all about it. On the 1st of June 21, they served a notice of action, acting on behalf of the GLD served the notice acting on, and then they took part in the whole proceedings between that time and the hearing between the circuit judge. At no stage there was a point raised about service. They, as I outlined in my submission, my lord, the details about what is considered to be good service, effective service, I bring back what Lord Clark said in Abella. The main purpose of service is to bring the matter to the attention of the parties. Now, the matter has not simply been brought to their attention. The parties all know what is completely the issue. They have been in correspondence with the court about different stages, the different orders, the order of the event 1, event 2. They are aware of the judgment of His Honour Judge Latham, they have taken part in all these proceedings with the court, and there's no way of coming after 18 months and tell the court, sorry, you have never been served. That is not the law.
Well, I'm sorry, it's Dr. Alani, isn't it? Dr. Alani, I understand your grievance about the way in which that issue was treated. I'm not sure it's something which is directly relevant to what we have to decide today, but thank you for making those points. Now, should we get back to the application before us?
Yes, of course.
What would you like to say, in addition to what you've said already in paper? What would you like to say in support of the application? And in particular, we want to focus on where you say this case should go from now.
Well, I think if I first start to address you on the permission, if that's what you want me to do, or are you convinced that there is no need?
I think it will be helpful to us if we could roll the whole thing up together. And as I say, try to focus on what you think what you say should happen now.
Well, I think what should happen now is for me to try to convince you of what is the effect of nullity and how it affects the outcome of the judgment of the Deputy High Court. Because if we do not address the question of nullity, we are nowhere near to understanding how the matter got to the judicial review stage, my lord. This is what I think is at the heart, and I intend to address you on nullity and its effect, relying on the authorities which I had filed before your lordships. And if I succeed on that, then I think that the only possible judgment which we think the court should make is that for the whole case to go back to the county court to deal with the application set aside and everything in between.
I'm sure it's my fault, but Dr. Alani, please forgive me. So you're going to invite us to grant you permission to appeal, and then allow the appeal?
Yes.
Against the deputy judge's refusal to grant you permission to bring the judicial review proceedings.
Yes, my lord. Yes, my lord. And the reason for that is if the Deputy High Court judge was dealing with a nullity, then the whole proceeding is a nullity, as I intend to show you from the judgment of the House of Lords in...
are you going to ask us to what are you going to ask us to do if you persuade us of that?
To decide that this matter should go back to the county court to be determined in first instance. That is. I'm sorry, my lord.
No, my fault. So what you like us to do is, as part of the ratio of our judgment, say that Appellant 2 and all that followed it was a nullity. On that basis, if we declare it to be a nullity, it's gone. And you would also like us to say that, as is accepted by Ms. Milligan, you're entitled to your hearing on the 3rd of your application to set aside Appellant 1.
I couldn't put it any better, my lord. Yes.
Well, I'm sure you could. But one of the things that we can't do is express any view about the merits of the underlying claim.
I'm not asking you for that.
No.
I'm not asking. I think this should go to the first instance court to determine the merits of the case. Is still a question which will be determined in the hearing of the 3rd of the application on the 3rd of March. This is basically what's the job of the county court would be. I don't expect that to be. In fact, my learned friend said that your with all due respect, your court is not seized of the issue of the, and I accept that argument. I don't want to push it, but she's eloquently put it in that sense, in that way. Yes.
Well, just how I have total sympathy for the contention that something has gone very wrong with Avent 2. Whether or not it's strictly a nullity, whether a court order with a stamp on can be regarded as a nullity, I think is quite a difficult question. It seems quite clear to me that it was ineffective and should be set aside. However, the difficulty for us in this court is that not only does it seem to me that that is not an issue before us, but it's an issue, it seems to me, upon which the CPS would have to be heard, because they are a party to that order. And it's unfortunate, I think it's very unfortunate the CPS hasn't engaged in this, because the simple answer to all of this is for the CPS to say, yes, we accept this has all gone very wrong, we accept that everything should be set aside and that we should all go back to Avent 1. And if they agree to that, which is as an organisation that specialises in legal proceedings, one would have thought that would be a fairly straightforward thing for them to do. And that is the way this should be resolved, in my judgment. But I think what we cannot do is make orders in relation to Avent 2 in proceedings to which the CPS is not party and has chosen not to.
My lord, what followed Avent 2? If Avent 2 was null, what followed is a consideration of an order. I mean, in the case, in the judgment of the House of Lords in Rage before your lordship, Lord Evershed said there is no such thing as an order which is null and void unless the proceedings are null and void. So, and he on top of that, he said there are no degrees of nullity. An order is either valid, voidable, or void. There is nothing in between. So, if the lordship accept that District Judge Avent made a null and void order in Avent 2 because he had already, and incidentally, if you look at his comments in the witness statement by Rose Nesbitt, you can see that he's not really consistent, because at one point he says this was electronic, on the certain it's actually handwritten, and the reasons given in Avent 1 are very different to the reasons in Avent 2. While at the same time, the judge had the application to set aside before him. So why would he make Avent 2 if he had made Avent 1 and the application to set aside is before him? Now, may I just continue?
Yes, of course.
Now, Avent 2 led to a hearing, to a determination by Circuit Judge Latham. Now, Circuit Judge Latham was handling a void, a nullity, basically. So how could his judgment make any difference? The authority of the House of Lords in it says no decision, however lawful, even if made under statute, an act of Parliament, would rectify a nullity. So the order of His Honour Judge Latham was itself a nullity. The case came before Her Honour Judge Bosher was a reconsideration of the order of Latham. And if the order of Judge Latham was a nullity, then her reconsideration would have been a nullity.
Yes.
This led to the judicial review application.
Yes, but of course, could I just point this out, Dr. Alani? These points you're now making are points on which you would take, if you had to, on the substantive judicial review application. That's not before us. We're only concerned with whether to allow an appeal against the refusal of permission to bring the judicial review.
Well,
we can't. How do you say we can do anything to determine that you're right about that? That it was a nullity. I see the argument. How can we make that decision without giving the CPS a chance to be heard on it?
I'm not inviting you to make a decision without the CPS. The CPS chose not to take part in these hearings, my lord. we appealed against a judgment which we think was faulty, which we think was wrong. We have no ability. The appellant has faced an enormous miscarriage of justice throughout, from the 3rd of March 21 until today. The 3 years of litigation running after his case, a person who has got no funds, living on pension credit. I mean, it's remarkable that we even reach this stage. We have no control on how this process should go. We seek justice.
Can I put forward one possible way forward? It would seem to me, for my part, let us say we granted permission and then the judicial review took off to consider your argument that that Judge Bowser's order should be set aside on grounds that it was a nullity through the judicial review proceedings. I mean, that would be could be a fearful waste of time and money, given that the real issue is, as we agreed at the outset, the real thing that needs to happen is Appellant 1 needs to be resolved. So would it be a solution, if we could do it, and I have to think about whether we could do it, is it a solution if we were to allow the appeal against the refusal of permission, but then stay the judicial review proceedings for a period of time to enable all of you to go back to the county court for the hearing in respect of Appellant 1 to take place?
If it does justice to the appellant, I have no objection.
Do you? Well, what? I'm just trying to think how that. I'm not sure it would work. I'm not sure my colleagues would agree it would work, and you'd have to tell us whether you thought it would be just.
You had a costs order against you in front of Judge Boucher, didn't you?
I beg your pardon?
Am I right in thinking you had a costs order made against you
Yes,
by Judge Boucher?
yes.
Has that been paid?
No, I don't think the appellant is penniless, my lord. I think I have made that repeatedly clear to the judge.
And what about before Deputy Judge Locke? Was there a costs order made there?
No, there was no cost order before the Deputy High Court judge. No, he made specifically no cost order.
So there's only there at the moment there would only be one costs order that would need to be unravelled if Appellant 2 is going to be cleared out.
So
speaking for myself, I'd like to see the authorities.
Yes. Okay. On what?
Nullity.
No. Oh, right. Well, then we'd like you just to develop your point about nullity by reference to the authorities. Would you do that?
On
nullity.
On nullity.
You said you were going to refer to the authorities.
Yes, my lord. My lord. Yes, my lord. Yes, my lord.
What would you like to show us?
Yes, I will. I'll try to. If you kindly, my lord, consider look at the bundle, the authorities bundle.
Yeah, we've got it. Here it is.
Let me just have a look at this.
So we've got the Seaver case to start with. The first one in the bundle. Where do you want us to go?
Well, I would like you to look at page 51 BC.
Is this the Hodinot case?
No. One of these are. This is the anismenic.
This is in your bundle of authorities.
Yes, the 692 pages.
Yeah. Hold on.
Which I haven't got.
I've got it electronically.
Good. I just could I ask your JA to go and get my computer?
Yeah. Where is it?
It's in my room. Yeah. I wonder whether Lord Justice Stuart-Smith's judicial assistant would go to collect my computer, which is in my room. Thank you very much.
Lord, in the meantime, why don't I hand my iPad up to you, and that will allow you to navigate.
It's only a minute away, so you carry on. I'll catch up. You get going.
Thank you, my lord. Thank you very much.
I'll look over my lord's shoulder.
It's page 51 in the case of...
Well, Lord Justice Phillips is just finding it now. 51 in Anasimic.
Yes, my lord. It's
Just one moment.
Just a moment. Judicial. The RCJ Wi-Fi is a little slow. Not as, unlike council's chambers, it's not state of the art.
Yes, we're there. Can you give the page number again?
Page 51.
Yes.
There's a bar on the right-hand side.
Lord Pierce.
Yes. And there's a bar on the right-hand side between B and C.
Yeah.
Yes.
Yes.
which tries to identify what a lack of jurisdiction may involve, and says there may be an absence of those formalities or things which are conditioned precedent to the tribunal having any jurisdiction to embark on an inquiry, or the tribunal may at the end make an order that it has no jurisdiction to make. That particular sentence is what I rely upon to say that the judgment of
I don't think this situation is quite what has in mind though. The district judge plainly did have jurisdiction in the case and did have jurisdiction to make a strikeout order.
but there was no claim before him on that day because he had already struck it, my lord. In event
I
one,
understand that, but I'm not quite sure that makes his order a nullity. When look at it this way, if you do set aside Avent 1, what's the status of Avent 2 then?
well, there's no event two if there's no event two because the claim didn't exist on the 1st of May 2021 because the judge had already struck it. It is not non-entity.
But it was plainly an ineffective order and one he should not have made. But this is an order of a district judge with a court seal. I think it's very difficult to say it's a nullity myself, but there we are.
It's certainly ineffective.
Yeah, well, ineffective or
Certainly ineffective.
well, ineffective or void to me, to a layman sounds the same. To the appellant, it's the same.
Yeah, unfortunately, we can't necessarily go with the layman's understanding.
Well, my lord, I appreciate that, but if it's ineffective in law, what does it mean?
But that's all you need, isn't it? You don't need this to be a nullity. All you need for present purposes is that this was an order which should not have been made, that the circuit judge should have so found on appeal, and if necessary, the deputy high court judge should have given you permission to judicially review it because of what had happened.
Well,
That's all you need, isn't it?
That is fine.
Well, I think that's an open door at the moment.
What-
Both.
Sorry, my lord, if it's ineffective and has the same effect as calling it nullity, we call it nullity and the effect in law, it is ineffective, and a nullity is ineffective in law. That is all we're saying.
Well, we may be dancing on the head of a pin, but we don't want to get wounded by it.
It's all very interesting, and my Lord Justice Phillips may have the solution in what he's just said. But other authorities, we've read your skeleton. Is there anything in particular in the authorities that you want to take us to on this question of ineffective stroke nullity?
Yes, yes, my lord. I want to carry on, bring further few more principles from the authorities before you. They are not in my skeleton argument, but they are in the authority bundle.
Okay.
Yeah. If I may take you, my lord, to page 133.
Rudin Baldwin, Lord Devon.
Yes. And
Do you want us to read that passage that's marked?
yes, my lord. I think not the whole part. I think what I wanted to emphasize, what his lordship said, it is necessary always to bear in mind the distinction so clearly drawn by Lord Sumner in Bell between a wrong exercise of his jurisdiction, which he has not, if there's and a usurpation of jurisdiction which he has not, I beg your pardon. If there's no jurisdiction, the decision is a nullity, whether the court quashes it or not. I'm sure your lordship is going to tell me that District Judge Evans had jurisdiction on the 1st of May to issue Event 2. We respectfully submit that he did not. He had no jurisdiction to strike out a claim that was already struck out. The claim on the 1st of May did not exist. It was struck out. So he had no jurisdiction to strike it out again. That makes it a nullity, according to the judgment of his lordship. The third, then I would like you to look at page 102. It's a long passage, but this is important.
Say again.
102, my lord.
102.
And this is if there is I think you have got a bar at and this is where
This is Lord Evershire.
yes. This is an important it's an important submission on our part. It says, my lord, it's perhaps useful and necessary to inquire what in truth is meant by saying that a decision such as that of the Watch Committee, in that case, of course, in the present case, is void or a nullity. It is therefore, is it thereby intended that though the proceedings up to the pronouncement of the decision were proper and effective, the decision itself was a nullity? Or, now you have the word, sorry my lord, the word of being effective or ineffective. His lordship seems to equate that with being void. Or is it intended that the whole proceeding ab initio were irregular and inefficient, so that the decision was similarly and of necessity also of no effect? My lords, the latter must, in my judgment, be the true analysis. My lords, we rely on his lordship assertion here that basically when an order is null or void or ineffective, then the proceeding that led to it would be void and ineffective. And I can't add anything to what his lordship said.
Do we need to look at the next paragraph?
Sorry, my lord?
Do we need to look at the next? I'm sorry, Dr.
But you mean
the next
no.
paragraph where
No,
Lord
my lord.
Evershire says, in the vast majority of cases,
No, my lord.
it matters not.
No, that bar extends beyond. I think we stop at where in the but to examine the steps taken in reaching the decision and to decide whether in the course of these steps there was a real substantial miscarriage of justice. This last sentence applies very much to the case of the appellant here, my lord. Yeah. There was a serious miscarriage of justice throughout from 2021.
Dr. Alani, something has to be done about Advent 2, doesn't it? It can't just be left.
It's null and void, my lord. It doesn't exist. It doesn't, because there was no jurisdiction to make it.
I understand you say that, but nevertheless, something has to be done about it, doesn't it? If you leave it there on the court file, something has to be done about it. It has to be quashed or set aside.
Well, in unison, my lord said, if it's now ab initio, then there is no need for a court to take action. It's already dead. I think I put that in my skeleton argument, if I may. Okay, there it is, my lord. It's in paragraph 5, in paragraph 6 of my skeleton argument. That is page 120 on the core, in the core bundle.
Yes, it would therefore be quashed, yes.
As Lord Pierce said in an Hispanic, where a decision is found to be in excess of or without jurisdiction, there is strictly no need to quash it, since it is a nullity.
That's right, and that may be the case in relation to a decision, but we're talking about a court order here with a seal on it. How does anybody know? How does anybody know that it's a nullity and shouldn't be acted on unless something's done about it?
Was the order not perfected in Anna's minute?
But wouldn't that have been the job, the due function of the circuit judge who considered
Yes.
event 2?
But presumably, at the very least, you have to make a declaration that it's. The court would have to declare that it's a nullity, at the very least. I'm not quite sure. But if we did absolutely nothing, I'm not sure how that would help you.
Well, I am only reciting what the learned Lord said.
Yes.
Need strictly no need to quash it. He said there's no need to quash it. It's a nullity. That's what the Lord said. That's what Lord Pierce said. Who am I to comment on this?
Well, of course, it's strictly right to say that if something is a nullity, then it doesn't exist. But that's not a very helpful result of court proceedings if, as the result of it, an order just stands there with a court seal on it. Surely something has to be done as a matter of good administration, if nothing else. Even if it's just a declaration of the court that that order is a nullity. Is that not what you want? Do you not want to get rid of Avent 2?
I want to get rid of Avent.
That was what your appeal was.
Yes. Because if Avent 2 doesn't exist, everything that follows.
So why does it matter? Why does it matter? Forgive me. I really do understand the points you're making, but I'm not sure why it really matters. All you want to do is have Avent 2 quashed or set aside.
That's right.
Yes.
That's right, my lord. Yes, because if it follows from our submission, it follows that if Avent 2.
So why do you need to take on the burden of showing it's a nullity? Why not just simply say it shouldn't have been? No, I don't think no sensible lawyer could suggest that an order of court striking out a claim which the same district judge had already struck out was of any effect. So I think you're shooting at an open goal. The only question is, what do we do?
Declare it doesn't exist.
Whether it exists or not.
Well, I mean, if the court decides that Avent 2 doesn't exist or ineffective, that we're satisfied with that, even if it's not called as a nullity. But the purpose of why we're saying Avent 2 is ineffective, because the whole proceedings that followed were based on considering Avent 2, and if Avent 2 collapses, then the whole proceeding will collapse. That is our submission.
That's your fundamental submission.
It is, my lord.
If Avent, let's go back to the layman's use of language. If Avent 2 is a nonsense, then everything that follows it is a nonsense.
Well, that's the only logical consequence, my
Or
lord.
if I become a bit more technical and take my Lord Justice Phillips's approach, if it's ineffective, then what follows is equally ineffective.
That is, my lord. That is the perfect conclusion we would
So
submit.
coming back to my Lord's question to you, you don't need the word nullity as such, I think is the point that's being made.
Yes. Well, if that is your conclusion, we're satisfied with that, my lord. I don't use the word nullity. I give up. I stop
Don't give
raising
up.
the question of nullity.
I don't need to give up.
I stop.
I think the point is, it may well be that it is a nullity. It may not, but I'm not sure that's before us today. And I don't think it's necessary for you to show us that it's a nullity in order to succeed on your judicial review.
May I be honest with you, my lord, and say the only reason why I took on the job of establishing its a nullity follows from the order of Lord Justice
Yes.
Stuart-Smith.
Well, leave me out of it.
Yes, who suggested
So it's his fault, is it, Dr.
that he said it may be a nullity, and I thought, well, that is a perfect approach. If His Lordship believes it's a nullity, then why don't I rely on it? Okay, that is indeed, that's the honest truth.
Well,
my
I'm glad we've got to the bottom of
Yes.
who the culprit was, Dr. Al-Arani.
All right.
Anyway,
I'm
I
grateful,
think we've reached
grateful to His Lordship enabled me to make a sound skeletal argument.
well, it's been interesting going through those authorities, but I think we've probably reached consensus about that, subject to hearing Miss Milligan, of course. Now, where do we go from here?
Well, my lord, if you accept that event 2
Has no effect.
has no effect, then what is the meaning of the judgment of His Honour Judge Latham, who considered an order of event 2 himself? What is the
So
meaning of
the way we could get there, I'm just thinking aloud, and make the ineffectiveness of is to make the ineffectiveness of event 2, which seems to me to be uncontrovertible and unarguably the case, subject to Miss Milligan. And we say that of itself is a reason why judicial review, the permission to bring the judicial review proceedings, then that becomes part of the ratio of our decision.
Yeah.
It may not technically bind the CPS if they really want to come along and instruct either Ms. Longson or someone else to come and argue that event 2 had some meaning. But that would at least give us a framework, I think, wouldn't it?
Yeah. Agreed.
Yes. But it seems very unlikely that the judicial review would be effective.
Yeah, I mean, it would be the peg, wouldn't it? It would be the way of resolving the matter for the moment. So yes.
We would declare, we wouldn't ourselves set aside event 2 because that's not before us as an issue. But I don't, at the moment, I'm inclined to think, speaking entirely for myself, that I, speaking entirely for myself, would be prepared to say event 2 is so clearly a nonsense that we can say it's a nonsense, ineffective, and that has these consequences. And I'm somewhat reassured in that outrageous boldness by the fact, as you point out, that the CPS took no part in any of the no active part. If they'd wanted to be heard on it at any stage, they could have been.
And their position is safeguarded because Avant 1 is still effective, and they can argue whatever points they want to on the substance.
No injustice will be done to the CPS, my lord, because the hearing of the application, because the hearing of the application on the 3rd of March is set aside, will be open to both parties to come to the to county court and argue their cases. The appellant will argue why the claim shouldn't be set aside. The CPS will have the opportunity to argue its case, and justice will be done. I will be very content with that.
The one issue though, which does need to be addressed somewhere, are the costs. Is the costs order that the circuit judge made?
Well, they would go if we declare it all to be ineffective.
Well, my lord, if it follows that if event 2 is ineffective,
Yes, I accept that if we were to declare it all ineffective, then it would go. I agree.
then there would be no cost for the circuit judge in the hearing before Bosher, because the circuit judge was considering an ineffective.
Yes, I understand.
Effective order. Thank you, my lord.
Right. Well, it's been very interesting, Dr. Al-Arani, and for my part, I was conscious reading the transcript of the hearing before the circuit judge that you perhaps didn't always have an opportunity to complete the submission you wanted to make.
I wasn't allowed at all, my lord. I must say, I wasn't allowed to.
Well, I don't. Let's not.
Okay.
Forgive me for interrupting you.
Not at all.
Having just
Not at all.
forgive me, But I don't think it would be necessary to have a post-mortem of all that. But I do want to make sure that you have every opportunity to say whatever else you want to say on this application and appeal.
Thank you very much, my lord. I'm very grateful. It's very obvious that you have heard everything all the parties have filed, and I'm grateful. I don't want to elaborate on the several injustices that I have faced in these proceedings. It has been very agonizing 3 years of chasing a case which should have stopped on the 3rd of March. Almost, what is it now, 4 years now? 3 years now. And a month less than a few days will be 3 years. And all these proceedings for 3 years have been completely unnecessary. Waste of time for everybody, including your lordships.
Well, shall we leave it there so far as you're concerned for the moment?
Yes.
And see what Miss Milligan says. Do you want to ask Dr. Allen any more questions? Anything else? So we'll leave it there for the moment. Come back to you on reply, of course. Let's hear what Miss Milligan says now.
Thank you very much.
Thank you, my lord.
Thank you again for your helpful skeleton.
It's my pleasure. And can I start by saying, as I think is probably appropriate, I know your lordship will be aware, but as we're in an open court, it's probably right to say that usually my client would be entirely neutral in these sorts of proceedings, but it recognised, well, indeed, we were directed by my Lord Justice Stuart-Smith to participate because of the unusual set of circumstances in which we find ourselves. The respondent is nonetheless neutral as to the outcome of the proceedings, so whether that be this appeal or the judicial review. The respondent expresses no view whatsoever on the merits of the underlying case. My only instruction is to assist you to the best of my ability. So I'm not arguing for a particular outcome. I'll simply offer you all of what I consider to be the options and leave you with the job of choosing which way you would like to go.
Thank you.
I had envisaged, before hearing your opening remarks, taking you through 4 sets of submissions. I suspect I can take them a slightly bit more of a canter, but it is still necessary for me to set out that framework and to go through those four headings. I've obviously heard everything that your lordships have said, and I'll address that as I go, as well as the points that Dr. Alani has made. If I may say so, the written submissions that I filed were probably an attempt to untie a Gordian knot. And my approach today is to help the court cut it. And so I'll perhaps be a little bit more direct than I was in my written submissions. So the 4 headings of my submissions are, number 1, how is this appeal to proceed and what are the court's powers? That's obviously something that has concerned the court this morning. Number 2, the status of event 1, event 2 and other matters leading up to the hearing before Her Honour Judge Boucher, and that will include what this court may do about it. Number 3, Her Honour Judge Boucher's order and the appellant's challenge to it. And then number 4 is finally, what next? What do we do from here? What are the options available to the court? I suspect that by the time we get there, we might have covered that, but we'll see how we go.
Can I just ask you, in your neutral position, I take it you don't have authority to agree to Judge Boucher's order being set aside?
I do, in the sense that if that is an option open to the court and the court wishes to take it, we would agree to it and we would not oppose it. I'm not proffering it as a sort of, please do this.
You're doing a Dr. Alani, you're saying it's all my fault.
Not at all. I'm saying it's your decision, and we would, if that is your decision, we would stand by it, and we are happy with it.
But how could you agree that without one of the parties to the case being heard?
Well, what is going to be the thrust of my submission is that we are concerned here with a judicial review. a judicial review can set aside an unlawful court order. I'll come on to it, but
I see.
the order
And it's
needs
review
to
against
be.
you.
Yes,
So you say you can agree to that being done because you can see that it should be done.
we could compromise the judicial review. We could have done that at the first instance. Obviously, we weren't really involved in the sense that we
Yes.
are now. Subject to the fact that a court order has to be quashed or set aside. I'll develop that, but it can't simply stand because the parties have said we're not going to bother complying with that. It has to be ordered to be set aside.
Could we do that without hearing the CPS?
Yes, because if this were the administrative court and we had proceeded to a judicial review, so long as the CPS were on notice, as they were as an interested party, that the allegation was that the decisions were unlawful and should be set aside, the administrative or divisional court would go ahead to consider whether or not the grounds were made out and whether or not to make that quashing order.
So CPS would have been given notice as an interested party,
Yes.
but the lease or whatever it is, the issue would still be between Mr. Koro and the Central London County Court,
Yes.
and therefore the administrative court could set it aside.
Yes, because the appellant's central argument is this is an unlawful court order. In your superior jurisdiction, supervisory jurisdiction, you must set it aside. And of course, it's always open to any interested party to come along and say this is why it's not unlawful, or under the Senior Courts Act, Section 31, the outcome would have been the same. So please refuse relief. But the quashing order, the ability of the administrative court to quash a court order, it exists.
Is it a problem for us that all we technically have in front of us is an appeal from a refusal of permission to grant permission to judicial review?
To some degree, yes. So the options are the court.
Have we now, I'm very conscious of your extremely impressively structured submissions. Are we now on number one? How is the appeal to proceed and
We
what
are.
can we do?
We are.
Right.
Thank you for
So
reminding
we've
me of our
landed,
sign
we've
for-
landed back at the theme, yes?
So usually, perhaps in more normal cases, what we would be doing, you would be doing as a court, is considering whether the decision by David Locke KC as to whether or not the claim was arguable was wrong in any way or for some other reason unjust. And then it would either go back to the administrative court for reconsideration of permission, or this court can proceed by way of a rehearing of the permission application. I will take the court to the relevant authorities, but just by way of
Yes.
overview, the court need not be constrained to a review if the circumstances are exceptional. That's generally the test. I'll develop it, but if the circumstances are exceptional, rather than doing a sort of classic review of David Locke's KC's decision, the court can have a rehearing, in effect, as the Court of Appeal, of the permission decision
And grant permission.
and grant permission.
Yep.
There is another option that is perhaps slightly more, perhaps drastic is the wrong word, but unusual, in that this court could also reconstitute itself as the divisional court. You have all the powers of the court from which this appeal arises, and say, by virtue of everything we have been through in assessing all of the matters in this case, we are in a position to sit as the divisional court and simply grant the judicial review. Whether or not you wish to do that is a matter for your lordships.
And again, we could do that with your consent, if you if you agreed to us doing that on behalf of the respondent.
Yes.
But would we have, what about the position of the CPS again? Does the fact that they've been given interested party notice of this hearing mean that they are taken to have notice of all the powers that we could exercise, including the ones you're now telling us about.
Yes, it's a matter of law, and it should be well understood by any lawyer that the Court of Appeal can proceed as a review or a rehearing court, and that it has the powers to constitute itself.
Right. So you're so if we did that, we could then hear that. We could then conduct the review ourselves. Couldn't we?
My submissions, if it exists, as to whether or not this appeal should be allowed, bearing in mind I'm neutral on the outcome but going to assist you, seem to cover the large ambit of what would be argued in any event in a judicial review.
The course I put to Dr. Alani was that we would, if we granted permission, we would adjourn, would stay. When I said stay, didn't I? Stay or adjourn the JR proceedings for a period of time to allow. I'll come on to what's to happen about Avant 1, to allow the Avant 1 process to be completed.
That course strikes me as difficult because the orders that follow would remain in place. And so, strictly, a county court judge who receives the listing of Event 1, the application to set aside, has to look at the court orders on the same level and say, well...
So you say, adopting a phrase which county court judges used to use when I was your age, Miss Milligan, we need to grasp the nettle.
That's an option that's open to you. That's all I'm here to...
But could I ask, if we did embark on the substantive judicial review and granted it, all the judicial review is a review of Judge Boucher's refusal to grant permission to appeal?
Not necessarily.
Right.
Because Her Honour Judge Boucher's decision and the reasons as to why it may be found by this court or the administrative court to be unlawful flow back to the application to set aside Event 1. So, in a nutshell, I don't want to oversimplify the position, but if this court or the administrative court were to find that the procedural irregularities that occurred in the administration of the Central London County Court rendered Her Honour Judge Boucher's judgment unlawful, it would be very unusual for the administrative court to simply quash Her Honour Judge Boucher's order, but then leave the other orders that it had said were procedurally irregular and amounted to a denial of a fair hearing alive.
So in terms, are you saying that the judicial review will be open to the judicial review court to quash not only Judge Boucher's order but also Avant 2?
Yes. I couch that with the qualification that that's not in the judicial review claim form, it's not in the grounds of appeal. So whether or not the court wants to take that approach, that perhaps merits some consideration. But in terms of strict legal powers, yes, because the administrative court is a court of supervisory jurisdiction, and so if it becomes aware in part of the determination of Her Honour Judge Boucher's order as to whether or not that's lawful, if all of the other court orders are sort of set up and bound within that, it's difficult to see why, seized of the procedural irregularities in the Central London County Court by virtue of the judicial review, the court's supervisory jurisdiction wouldn't extend to those.
Apart from Avant 2, is there anything else you say we could or need to think about quashing in addition to Judge Boucher's order?
Her Honour Judge Boucher's order, Event 2. No, that's it.
Judge Letham's order.
Well, I suspect not, because that was reconsidered by Her Honour Judge Boucher. So it's made on the papers, and then the appellant applied for an oral reconsideration hearing. So much
Bells
like
and braces, shouldn't we deal with that as well?
perhaps we might then get into the question
Yep,
of whether that's
You say Judge
ineffective
Latham's
or-
order disappeared when it was reconsidered by Judge Barrett.
Yes, much like with a permission, a judicial review permission decision on the papers, if one then says, I'd like to have an oral reconsideration hearing, if the judge hearing that oral reconsideration hearing goes the other way, one's not in difficulty.
Okay, so nothing else.
What about an order directing that the application to set aside Avent 1 be listed?
I can't see any problem with that. The natural consequence.
Is that would that be part of our supervisory jurisdiction as the Court of Appeal supervising the administrative court?
No, that would be if you were to reconstitute yourself and grant relief that a divisional court could.
Okay, right.
And in fact, it technically would not be relief in the sense that the natural corollary of your decision, if you were to make it, to quash the other orders would be, well, we're left with, as I said in my written submissions, there is still an outstanding application that needs to be listed. So
What's an order of mandamus then?
it could be, whether or not it's necessary.
But it should be sufficient whether we make an order or not. If we say,
Yes.
in words of one syllable, it must be heard.
Yes. Whether that's in your reasoning or in a mandamus order, either way it ought to happen.
Remembering the convoy moves at the pace of the slowest ship, which in this case is me, do you have any quick and easy authority to cite to us in support of your proposition that we can do all this?
Quick and easy authority, I'm not so sure. Both the CPR and the Senior Courts Act, I'll have to get the precise provisions up,
It's in the rules.
give this court the power to exercise all of the powers of the court from which the appeal stems.
I don't think you've set them all out in your written submission.
No, I haven't.
Would you be able to just provide a note after just giving us chapter and verse?
Absolutely.
Shouldn't be one. Yes, carry on. So where we've got to so far is that it's all in the rules and in the Act,
Yes.
which which no doubt you could reduce to some.
Yes, the main provisions are Section 15 of the Senior Courts Act.
Okay. Do you want to split that up?
And CPR. Well,
Well,
it
no,
depends
we've
whether you would like
only
to
got
see
one copy of the old white book now.
Yes,
Okay,
I'll
right.
do the work later.
Okay,
of course.
right.
But I'll just say it for completeness
Section
now.
15 of the Senior Courts Act.
And CPR 5250. In
52.
relation
Oh
to-
yes.
In relation to an appeal, the appeal court has all the powers of the lower court.
Yes. Right. Thank you.
It is, as I said, more usual for this court to reconstitute itself in granting permission rather than going that additional step and hearing the substantive judicial review. It may be that is a decision that the court wishes to take once it has heard full submissions, and then your lordships can consider is the court seized of enough information to be able to make the same determination that a divisional or administrative court would do? Are we in the same position, in effect? Or would good administration require this to go back down and have further arguments about X or Y?
What part of part 52 were you referring to? 52.
50.
50. Right. Yes. Carry on.
That can't be right, can it?
No. You said so
You've been very
confidently that I
polite.
believed you, but my copy.
Thank you.
I think it starts at 52.
Maybe it's my
30.
handwriting. Maybe it's 20. Which
Well, yes, I think it
my
is.
instructing
It is,
sister has
it
very
is
kindly
20.
rescued me. Yes, 5220. I'm very grateful. My handwriting must be bad.
Yes. All right. So we've all got 5220.
Yeah.
Whereabouts? What in particular do you wish to refer to?
Well, one is just the same statement that you have all of the powers of the lower
Yes.
court. So in this case, it's the administrative court. That is effectively it. Section 15 of the Senior Courts Act, I can read to you if you bear with me. It's entitled General Jurisdiction of the Court of Appeal. Subsection 3, for all purposes of or incidental to the hearing and determination of any appeal and the amendment, execution and enforcement of any judgment or order made on such an appeal, the Court of Appeal shall have all the authority and jurisdiction of the court or tribunal from which the appeal was brought.
Well, why does that extend to the substance of the JR application as opposed to just the permission?
Because if we quash the order below, then we say we now exercise the powers that would have if it was remitted.
Yes.
And if we decide we've got enough, then we have the power. We have all the power that David Locke had, or would have had. Do we go back so far as to...
I'm not sure it's restricted to the power that Mr. Locke KC had, in the sense that it is the power of the administrative court to make a quashing order. The rule doesn't say you're restricted to, you have the power of the court subject to whatever phase of the proceedings the appeal had reached.
But it must be the case on this analysis that Mr. Locke could have said, not only am I going to grant them permission, but it's so obvious that this is all gone terribly wrong that I'm going to quash. He must have been able to do that. If he couldn't have been able to do that, then we can't do it, sure.
There would be an argument as to whether he, in his position, would have required to hear from the parties.
Well, it can't be any different with us, because that's
Yes.
the question of how you exercise that power, not
Yes.
whether you've got the jurisdiction to. And that you see I think is the real difficulty for us to grapple with, is not whether we've got the jurisdiction to do it, which I agree with you, I'm sure we have. It's whether we should.
Yes.
And how far we can go without going through a process which
Because the normal, forgive me, my lord.
sorry, at least giving the CPR the opportunity to be heard on.
CPS.
Yes, I can see the point that, for example, if Deputy High Court Judge Mr. Locke Casey wanted, in effect, he looked at it and considered this is clearly going to be, something's going to be quashed. There's no sort of summary judgment jurisdiction or anything like that. The usual course would be to order a rolled up hearing, just try and deal with it quickly, and perhaps to engage with the parties and say, has this been considered? Can the parties?
So I should have directed them to attend as well as you. I mean, I'm quite happy to take all the blame for this, but I think that because given where we are, and that Miss Longson doesn't have instructions, I think however we do it, we could either reach a provisional conclusion and invite the CPS to make submissions if they are so minded, which might require an adjourned hearing, because they could say at that point, okay, we accept that everything from Avant
Yes.
2 goes.
Yes. And
And if they wanted to argue against it, we'd have another hearing. And
yes, and the benefit of that course of action and adjournment means that this court, which throughout the course of today's submissions will, and of course pre-reading, has sort of gotten under the skin of this problem, will have a sense of what should happen, and it would be a shame, if I can put it that way, if seeing what the outcome should be, the sort of inability to simply make that happen required remitting it and the substantive proceedings to follow at cost to all concerned. And so the adjournment, perhaps at that stage, to reconstitute the report on the substantive issue could assist with all of that.
Well, if we were to allow the appeal,
Yes.
then the CPS knows that at the very least it faces a JR. Allow the appeal and grant permission.
Forgive me, my lord, but the CPS is not the respondent to the judicial review. The Central London County Court is, because of the
Well,
irregularity.
forgive me, it may not face it, but then it will at that stage will have the opportunity to make submissions if it wishes to.
Yes, much as it did at the earlier stage. It will always be, and it has to be by reference to the rules. It's an interested party, clearly.
Yes.
So it always should be given proper
Well, and it can be
notice.
directed to attend, can't it?
Yes, much like the
One hopes that
It directed to respond, and if it wished to take a contentious line, or a line different from the line that you. So that there will be nothing to stop us if we got to the end of today firmly of the view that we've got to unravel things to a greater or lesser extent,
yes.
which I think is that view is unlikely to change, and you will correctly have gathered that is our view. Then there would be nothing to stop the court giving a direction to the CPS as interested party or potentially interested party here, saying on the basis of what we've seen and heard, our provisional view is 1, Appellant 2 is ineffective and all that follows from it should not have happened. 2, we're minded to give permission, and if it's within our power to do so, to grant the JR. Give the CPS a week to respond in writing and to apply if they want to be heard. Could do that?
Yes.
And that might provide a route, because if the CPS then said, okay, we accept that Appellant 2 was legally ineffective and what happened afterwards should not have happened, and we consent to that being set aside,
Yes.
we have your consent, and then the way is clear. We don't really have to worry about jurisdiction.
Yes.
We only have to worry about jurisdiction and routes.
Yes.
Well, we might have to put in a paragraph explaining who we were when we did whatever we did.
Which hat you were wearing?
But you're going to draft that paragraph for us. So, but that would provide us effectively as a bulletproof way of clearing out Appellant 2.
I wouldn't use the term bulletproof. I would say that ensures fairness is done to all the parties, if I may say so.
Okay. Yes.
And that,
That's, I think, what I meant in using that technical
of course.
term. Yeah.
Okay.
Okay.
I'm sure. And as a final remark, I would say because it's so unusual for the Court of Appeal to reconstitute itself and hear the substantive matter, it may be that your lordships are of the view that effectively the CPS may not have had notice of that course of action because it's unusual. It might be a legal power that they ought to be aware of, but we ought to adjourn to give them an opportunity to participate on that basis, which is unusual.
Right. So subject to you giving us a note of what our powers are on what we've been talking about. That's it on court's powers, isn't it?
I believe so. I'll check my note in a second, but I believe so. The one thing to say is that even if, let's say, you receive my note and you say, well, Mr. Milligan's talking utter nonsense, all is not lost, because what I have to say by way of submissions that will follow do go to the heart of whether permission should have been granted, whether it's arguable, whether the claim passes that arguability threshold, and it would be open to the court to say, in the circumstances, having gone through all of this, we can't see how it could be the case that anything other than permission be granted be the order. But of course, as is always the case, we remit it and we leave it to the judge who's hearing.
Right. So that deals with number 1. Now you're coming on to tell us about what your submissions are on Avent 1 and Avent 2 and Judge Boucher's hearing.
Yes. So I'll try to take some of this a bit quicker than I had originally set out, but by way of brief introduction, Event 1 stated on its face that the appellant had the right to set it aside. It made reference to the wrong CPR provision. It made reference to 27, which concerns orders made ex parte by another party, rather than orders made of the court's own motion. So the relevant passage of the CPR should have been 3.3. For the time being, little turns on that, because in effect both require that the appellant be given an opportunity within 7 days to apply to set aside the order. The application was of course duly made. What we can see now, and I hadn't covered in my written submissions because it flows from the court file, etc., and what's been provided since, is that that hearing was listed. So I don't intend to take you.
The 28th of July.
Yes, and that was done on the 23rd of March. Deputy District Judge Welch ordered that hearing. I probably won't take up all the passages unless you want to go to them, but for your note, that's page 6 of the third supplementary bundle. What happens in the interim is not, as has perhaps previously been thought, that the District Judge Event then saw that application and made a further strikeout application. It's clear from the court file that the that District Judge Event was sent a duplicate file.
This is all during COVID, is it?
Yes.
And he just didn't appreciate he'd already made an order on the case.
That would appear to be the case. There's certainly nothing on the face of the order that indicates having considered the application to set aside. And if one looks at the court file in the third supplementary bundle, there are 2 case records, case histories. One sort of runs out very quickly and doesn't include the application to set aside, and that's the duplicate file.
So it wasn't a complete duplicate in that sense.
It was an earlier duplicate, I suppose one could say. It's a snapshot of.
It reflected the file as it had been, not as it was at that.
Yes, and
Which page are you on in third bundle?
bear with me one there, my lord. So page 12 of the third supplementary bundle. See first the entry 4th of December 2020. Request for judgment and file to DJ Event. That is the sending of the request for a default judgment.
Hold on. I haven't got there yet. Page 12,
Yes.
4th of the what?
December.
Towards the bottom, the three
Got it.
entries up, 4th of December
It goes
2020.
in reverse order.
Yes,
Sorry,
I might have said that, forgive me.
I might have spotted it. 4th of December. Okay. Yep.
So that is the request for default judgment going up to DJ Event. Court staff sending it to him. There is then in between the appellant, the claimant in that matter, chasing and saying, and you'll have seen some of this in the papers, why haven't you given me a default judgment?
E is an email, is it?
Pardon, my lord?
E is email, is it? No. Never mind.
I'm not sure what E is, forgive me. And so, as a consequence of this chasing, and I say that not in a critical way, there is an entry of the 16th of February 21, refer to District Judge, duplicate file to DJ Event with request for judgment. So, if I can try and put it in a colloquial way, someone is getting calls and saying, "Oh, we need an order. Send another one up, and hopefully that will flush something out." And so, but in the meantime, District Judge Event has already made his order, because that was made on the 1st of February. It wasn't drawn until after the duplicate file went up. And so effectively what one has is, I'm perhaps mixing my metaphors, but the two files crossing like ships in the night. And so of course I can't stand here and say what District Judge Event did or did not have in his mind, but it appears, having regard to the recital to his order and the court file, that he wasn't aware of Event 1.
Thank you.
I
Well,
should-
Judge Boucher says the court made 40,000 orders that year, doesn't she? In
I
the
can't
course of-
remember the precise
I
figure,
think it
but
was 40,000. She said in the course of
Okay. And
debate with Dr. Alani.
Then the entry above the 16th of February, N24 General Formal Order is Avent 1.
yes,
And
but it was
by that time the ships have passed in the night. The duplicate file is out there. And the inference is inescapable that District Judge Avent did not have Avent 1 in mind when he made it.
yes, and I would add to that 25th of February is a reference to the court staff drawing the order.
Yeah.
The order was made on the 1st of February. Let me
Yeah.
just find the page where I can show you that.
It's on page 123.
I'm very grateful.
Is Avent 1.
123.
The core bundle is Avent 1, which says at the bottom dated 1st of Feb.
I have a different 123, but yes, I know that the the first supplementary bundle that is, yes, it says at the bottom the date. There is internally in the third supplementary bundle at page 3, District Judge Event's handwritten note in which he makes the order and then sends that note to us that it be drawn by court staff. So at that stage, when Event 2 was made, Event 2 sought to, in effect, even if in ignorance, strike out a claim that was already struck out. So it's right to say that it was ineffective and that it didn't change anything. The language of nullity is incorrect in the context of court judgments. The case that you want for this is the Crown on the application of Majera, M-A-J-E-R-A, against the Home Secretary. It's a 2021 Supreme Court case.
Is that Rwanda?
Yes.
Yeah.
Where the court said the concepts of unlawful decisions being void ab initio is subject to important exceptions. I have a copy of Majera with me, if anyone would like it.
Is it in your? It's not your. Well,
It's not. Forgive me.
we've all got our computers. What was the reference?
2021
Supreme Court.
UKSC 46. And it's a
We can all-
unanimous
I assume we
judgment.
can all get that on. We go to Bailey. 2146.
I've got plenty of hard copies as well.
Very kind of you. We might need it. Got it.
And my apologies that this isn't in the authorities bundle because it came to my attention after.
Has
It
Dr.
was,
Alani got one?
would you like electronic or hard copy?
Doesn't either one would do fine. Either.
Well, I'll
Either.
give you a hard copy just in case.
Thank you very much.
I'm not sure.
I'm grateful.
Where should we go?
Paragraph 27.
Are under the heading are unlawful acts or decisions incapable of having legal
Yes.
effects. Yeah.
And so the bottom 4 lines, Lord Reed says, judges commonly use those expressions null and void. But the concept that the acts and decisions are utterly destitute of legal effect is subject to important qualifications.
Which paragraph? I'm sorry.
At 27.
Thank you.
And then Lord Reed goes on at 28 and 29 to say one of those qualifications is court orders. And this is the point made by my Lord Justice Baker earlier. 31, paragraph 31, Lord Reed says, treating the decision, this is about halfway through the paragraph, as legally non-existent may be inconsistent with legal uncertainty or with the public interest in orderly administration. It may indeed result in administrative chaos. And so the void ab initio analysis doesn't apply without qualification to court orders, which remain
Extant.
extant until they are set aside. They may be liable to be set aside or quashed because they are. There could be a nonsensical court order that everyone agreed couldn't possibly be of effect, but it is an order of the court.
Which has to be complied with until set aside.
Yes. Yes.
Lots of authority for that.
Yes.
Which is presumably is the latest.
Yes, as far as I'm aware.
And that's not affected by the fact you can't comply with Advent 2 because it's got nothing to bite on.
Well, there's nothing to comply with, but it remains an order
Yes.
and an effective one until something is done
Yes.
about it.
Essentially, the fact if you set aside Advent 1, would then, on its face, have an effect.
Yes.
Would it?
On its face.
Would it? Because the order's made on the 1st of May, or whatever date Advent 2 is made. There's not.
But that's the precise point. Even if it's nonsensical and illogical, it's a court order.
Right.
And so
fact, it's Hadkinson is the original case, isn't it? Going back, cited by Lord Reed in paragraph 46. Everybody has to obey an order,
yes,
unless and until the order is discharged.
yes,
The uncompromising nature of this obligation is shown by the fact it extends even to cases where the person affected by the order believes it to be irregular or even void.
yes. And he goes on at paragraph 49 to say it's consistent with the rationale of the rule of law, the maintenance of the rule of law, and it applies to courts of limited jurisdiction as well as to those of unlimited jurisdiction. So there's no concern about High Court versus County Court. And then it may interest the court to see that at paragraph 50, a judgment, the lead judgment of this court given by my Lord Roger Stuart-Smith is cited.
With great respect, I think,
Not sure.
I
if
think,
What's the vintage?
99,
1999.
99. I'm not taking responsibility for that one.
not immediate responsibility,
But
although
on the other hand, if Lord Justice Stuart-Smith said it in 1999, it is undoubtedly correct.
Well, Lord Reed seemed to think so.
Well,
So
that'll do.
so. This was another Lord Justice Stuart-Smith. You appreciate that?
no, I didn't.
That's right. Apart from the fact he's my father, we are not related.
I'm sorry. This is where coming from
That's
a
okay,
background of
that's
no
okay.
lawyers really bites.
Don't worry. I'm flattered. Anyway,
We resist the temptation to make any other further remarks, at
Can we move
least
swiftly
until we
on?
rise. But
Yeah.
now, it doesn't matter. It is it's a distinguished tribunal. We can agree about that. And what did you want to say about the substance of paragraph 50?
Nothing. Absolutely nothing.
okay, well, we've got the reference, thanks.
Okay.
So that is the status of event 2, and unless and until the administrative or divisional court does something about it, whether my lord is making me laugh.
Sorry, I'm trying not to. But can I just look at can I just read paragraph 15?
Of course.
Well, that's it, isn't it?
Yes.
That actually is absolutely, well, more or less on the point,
Yes.
because it's a judicial review
Of the respondent.
related to county court orders. There we are. You're right.
That's a shocking surprise.
Okay.
And so after event 2 was made, whether in light of it or in administrative error, the hearing that was listed to hear the strikeout application of event 1 was vacated by court staff.
Do we know that?
Yes, it's in the
Is
court.
that in the third supplementary bundle?
It is. If you bear with me, my lord, I can find it.
So does it explain why?
No. Well, let me qualify that. It refers to the case being struck out. And so it appears to be that a member of court staff may have thought, well, we can't list a hearing in this matter because it's now been struck out. That's supposition on my part, but of course it's very unfortunate and undoubtedly an error because the whole point of the application was to set it aside.
So where is that?
It is page 11 of the third supplementary bundle. A few lines down from the top of the page, an entry, the second entry for the 27th of July, miscellaneous. 28th of July 21, that's the hearing, vacated, case SO struck out.
Well, it has to say something has gone very, very wrong if that's the way it's dealt with.
That, my instruction and the approach that I took in my written submissions was made prior to having seen that. But I think I can say that there is general acceptance that things have gone wrong, and that is why I am taking the approach both in written and oral submissions I am, with the full consent of an endorsement of my client. Can I say unequivocally, my client wishes for the appellant and for this court to know that if things have gone wrong, it wants to be part of the solution and putting them right.
Thank you.
And so the consequence of that, of course, is that the appellant never receives the oral hearing to set aside the application, forgive me, to set aside the strikeout order. That it goes against CPR 3, which entitles him to that.
Yeah.
I suspect you won't need me to take you to it, but it goes against both Strasbourg and domestic authority as to the fundamental nature of an oral hearing before the appropriate tribunal, subject to exceptions, limited exceptions, none of which in my submission apply here.
Before we get to the reason why the hearing was vacated, you've got the previous entry, 28th of June, showing that the district judge had refused to issue the application to set aside
Yes.
Appellant 2.
Yes.
What's that about?
May I come on to that under my next heading, because it's just simpler to deal with it there.
Yes.
I've given much thought about how to present this with some sort of coherence, but I agree that is also a procedural irregularity. Well, no, forgive me, I have put that too high. That is potentially a procedural irregularity. That is probably a determination for this court to make, having regard to the case law I'll take you to. Some might argue it's finely balanced, so can I withdraw that and say that's a...
But that entry, the 28th of June, leads to the letter of the 12th of July. from the administrative officer saying we're unable to process your appeal.
Yes, it doesn't appear to have any connection with the listing of the application to set aside event 1, because simultaneously the court is writing to the appellant and to the CPS as the defendant, saying, is this hearing still effective? What's your time estimate, etc. So there are several trains in motion. And just to dot the I's and cross the T's, I can probably just take you to the relevant passages of my note rather than the authorities themselves. But in considering judicial review of these matters, this is, if you need it, it's paragraph 48 and 49 of my submissions. And in the authorities bundle, if you did want to turn to it, it is the first and second tabs.
Your authority.
Yes. Siva Subramaniam and Strixon. And the point that those cases make is that generally it's not appropriate to judicial review a refusal of an appeal application, because sort of you have to end the line somewhere, and you can't just JR the court when you've had all of your chances. The exception established in Siva Subramaniam and then elaborated on in Strixon is where there has been a pre-anisminic jurisdictional error. So that may be, and this is where the authorities that Dr. Alani took the court to come into being, where, for example, a court thought it had jurisdiction to entertain a claim and it didn't. That's more appropriate perhaps for the tribunals if one is thinking of conditional precedent fact that gives a tribunal jurisdiction, or a procedural irregularity of the kind that will constitute a denial of the applicant's right to a fair hearing, which of course we've discussed in the context of this case. So when the matter comes before the administrative court, and both on the papers and I believe in David Locke's order, though I'd want to double check the latter, there's reference to this, there's an error of law, it's not sufficient to engage judicial review proceedings Siva Subramaniam. The court may find, I don't want to preempt anything, but this court may observe that perhaps that exception was engaged here, because the appellant didn't receive a fair hearing. He didn't. The oral hearing is part of one's right to a fair hearing.
Well, it's the only hearing at all. It's because when a judge acts of their own motion in this situation, it's not something which the parties even addressed.
Yes.
So,
and that's the precise purpose of the safeguards within the CPR, to allow the set-aside application to be made, as it was.
yeah. I mean, the power of a judge, district judge or otherwise, under CPR 3, to strike out proceedings of their own motion is a draconian power.
Yes.
And however justified the judge thinks they are, and obviously they do strike out many cases which are on their face unsustainable,
Yes.
but nevertheless be very rigidly observed the right to come back. Otherwise, the access to justice is completely denied.
Absolutely. My lord may wish to bring up whether now or later the authority in my authorities bundle, if I can call it that for ease, of Le Bruchon Fay, which is tab 5 of the authorities bundle. It's judgment of this court in 2012, Lord Neuberger giving the judgment, and it was in fact turned into a practice note because of its utility. There will be plenty of cases, of course, on the need for an oral hearing to be held. But this one, and the if I just find the relevant page of the, so if your lordships turn to page 79, paragraph 22 and 24, are statements of Lord Newburgh that you no doubt endorse, but you may wish to read. And then the point that my Lord Phillips is making is indeed made by Lord Newburgh in his concluding remarks, page 82, paragraph 40 onwards. And if I can summarise it, and no doubt do an injustice to it in doing so, Lord Newburgh is saying courts have to make robust decisions. They will have to make decisions that engage their case management powers and further the overriding objective. That is to be encouraged, but it cannot be at the expense of an oral hearing, which is the point my Lord was making. One of the sad things about this case, I'm quoting, is that the judge's instinctive hostility to the applications may very well turn out to be quite right, if only he'd spent some time set aside for the applications listening to the arguments.
Did you cite that in your written?
I believe
That thing
I
about
read it.
the
You did.
hostility is just
Yes.
You did cite.
it's a
you
rather
did cite that.
striking quotation.
And in that case, it'd cost 9 months.
Forgive me, my lord, I'm not entirely sure. Yes, parties may well have been precisely where they were by the start of 2012. About the first 9 months a year, taken up with cost effort involved in the appeal. And clearly, I don't have the precise number of months and years that have taken place here. So I move now to what I said was my third limb of submissions in relation to Honour Judge Boucher's order. But within that, I will address my Lord Phillips' question as to the other events taking place on the file. My headline or starting submission here is that the hearing before Her Honour Judge Boucher was an opportunity to set matters right, because Her Honour Judge Boucher did grasp that the essential issue was that the appellant had not had an oral hearing.
That's at the beginning.
Yes. And so the question is, or the question that your lordships may wish to consider, is why didn't that happen? What went wrong? If indeed it did go wrong. But first of all, can I just now deal with the point that hearing before Her Honour Judge Boucher strictly should never have taken place, because obviously, as we've discussed, event number 1, there should have been a hearing to set that aside. When event number 2 came through, effectively crossing in the wind of event 1, the appellant again sought to exercise his right under CPR 3 and set event number 2 aside.
Which he was right to do.
Yes.
I mean, one of the, sorry to interrupt you, but one of the things that I found particularly depressing in preparing for today was the fact that on each of these applications, Dr. Alani set out the problem clearly. Anybody who had read his witness statements and grounds should have had the opportunity to pick up that there was event 1 and event 2, and that couldn't be right.
I think I would agree with had the opportunity to.
Yes, well, I corrected myself.
if I may say so, and without any criticism of Dr. Alani whatsoever, there was a lot of material within those submissions dealing with the underlying challenge and the CPS and what CPS should or should not have done.
Yeah, but in each
I agree.
document, he starts by setting out the background, and he puts it. It's all there.
I agree. What I was going to say was perhaps it could be said, and again supposition, that a busy judge is looking at that and missing these points. I'm not setting that as any form of defence or exoneration. That can happen. That's precisely the reason that this justice system bakes in those procedural safeguards. And so it is regrettable, to put it lightly, that this culmination of circumstances has occurred.
We've read the transcript of what happened, and we probably don't need to trawl through it.
I don't intend to trawl through it, but if in light of the court's consideration of remedies, I think it is necessary to make some points of law.
Okay.
That this
Can I just
court-
ask one point at the start? Am I right that Judge Boucher did extend time?
Did.
No question. There's no doubt about that.
I only asked because the
David
Deputy
Locke
High Court judge
thought she didn't.
said she didn't,
Yes,
and
that was his error.
He didn't have there's no sign that he had a transcript, because no transcript's been obtained until I think I directed one.
Insofar as I'm aware, yes.
You don't, there's not much on her order. It does, without doubt, say time is extended.
Time is extended. Yes.
I don't want to embarrass Miss Lunton, particularly given that she is here in person and is not instructed. But do you have any submission to make on whether it is appropriate in circumstances such as that to hear someone appearing for a party who has not acknowledged service, has not issued an application under Part 11, and has not served a skeleton?
I intend to address CPS's submissions as to service and whether they were right in law or not. The propriety of the CPS appearing before Her Honour Judge Boucher is probably not something I can comment on, because as far as I'm aware, it's a matter that's within her discretion whether she hears from them or not. I don't think I can take it any further than that, I'm afraid.
That's probably right.
That my Lord's observations may be something that a judge sitting in the position of Her Honour Judge Boucher may wish to give consideration to when analysing the merits of the situation. But I say that entirely hypothetically. So, the appellant should never have been before Her Honour Judge Boucher. He wanted to set aside event 1. That hearing didn't happen. He sought to set aside event number 2. When that happened, that is the reference that my Lord has made. This was referred to a judge. And I'll just bring up the relevant papers in the 3rd supplementary bundle. It's page 8, where Deputy District Judge Brayfield.
Sorry, page?
8. Was referred the application to set aside event number 2. And said in summary, please don't issue it. Go back and ask the claimant, should this not be an appeal to event 2 rather than an application to set it aside? The appellant was entitled to do either as a matter of law. I've set out briefly in my written submissions that one of the reasons for the procedural safeguard of a set-aside is that it is an entire re-review on the merits. It's not confined to the higher threshold of satisfying an appeal court that something went so wrong, as opposed to would the appeal court have made a different
isn't it a
decision.
general rule that one in these circumstances applies to set aside before appealing?
I'm not
an,
so sure.
an order or general rule. It's a common practice,
Yes.
certainly, isn't it? That you set it that where an order's been made
Yes.
on the absence of notice, the first remedy is to set aside before appealing, isn't
Yes.
that?
Well,
Across jurisdictions, that's what happens, isn't it?
Any sensible litigant would, because you then have the decision afresh, and if you don't like it, you then
You've
can
got-
appeal
you've
it.
got to appeal, yeah.
As opposed to being restricted to an appeal of a decision in which you had no say because it was ex parte.
This it seems to me that whilst there was an option, what the deputy district judge did here is quite wrong. It seems to me he wasn't entitled to not issue the application or direct that it not be issued, because as you say, he was entitled to apply, and then his reason is should this application not correctly be framed. Again, that's wrong. So this again seems to me to be yet another
Yes.
completely incorrect, lamentable piece of managing the process.
And the appellant recognised that and therefore sought to appeal Deputy District Judge Brayfield's direction.
It's,
Whether they'd have been entitled to apply to set that aside.
you could have done.
Yes.
And this is where we get to once we get into this sort of
Yes.
nonsense.
One of the reasons I do emphasise that he shouldn't have been before Her Honour Judge Boucher is because, not that I sort of want to sweep under the carpet these errors, to some extent they're all encompassed in the fact that
None of it should have
the
happened.
appellant shouldn't have been there.
I mean, Judge Letham's response on the papers, which I think is at page 91, it could have been done by JR, and he's right about that. But that's no basis for criticising it, because it was the decision of the deputy district judge that the application shouldn't be issued was wrong in law and could have been susceptible to JR.
Yes.
But equally it was susceptible to the route that Dr. Arani in fact took.
Well, what the court staff said to Dr. Arani was you can't appeal a comment from the judge, you have to have a court order. You can only appeal.
There's a catch-22, isn't it?
Well, I've set out in my written submission, the authorities are in the authorities bundle, but the power to appeal applies to a judicial determination.
Yes.
And so the case that I've cited at paragraph 47 and 1, Central Bridging Loans, judgment of this court 22, explains, Lord Justice Coulson, that determination doesn't have a statutory definition. What it is referring to is an outcome, a conclusion, something that has happened as opposed to judicial reasoning or commentary. And so, and this I find this line in paragraph 17 quite helpful.
Sorry, should we just get that out? I was just reflecting.
Yes.
This is your bundle of authorities.
Yes, and tab 7, page 189. And the final 4 lines of the sideline passage, speaking for myself, I find helpful. It is only the result that matters for the purposes of an appeal. That is why, although it is technically inaccurate, as this case demonstrates, judges are so fond of saying that an appeal lies against an order, not a judgment. And so, in that case...
That's the bit you cited that in your submission, didn't you?
Yes. In that case, His Honour Judge Dyte of the Central London County Court had determined that a transcript would not be prepared at public expense. That was the application made by the appellant. and it was said that's you can't appeal against that. It's not. There's no order. He didn't make an order. He just said that, and it was relayed administratively. You remember that earlier I rode back from my comment of saying that was an error. I think, as I said, it's a matter for this court to take a view as to whether or not Deputy District Judge Brayfield's direction was a determination that could be appealed, and therefore whether court staff were right or wrong to refuse to issue that application. But
But Dr. Alani's reaction to that was to threaten JR,
yes, although
which is, and then he backs off, having received the letter of the 9th of September.
I'm not sure I'd say it backs off. I think my reading of the situation, forgive me, Dr. Alani's right here, it's rather unusual to talk about you in the third person, but my perception is that the court staff are saying you've got an appeal and order, and so Dr. Alani on behalf of the claimant then says, right, well, I did want to apply to set aside event 2, but I'll have to appeal it if that's.
Yeah.
I've tried to apply to set it aside.
But this then feeds into Judge Letham's
Yes.
decision on the papers,
Yes.
when he says there's no good reason for
It being out of time.
for being out of time. Whereas
And the appellant's notice did contain within section 11 a description of the to and fro that had happened as to whether it had to be by an appeal or an application to set aside. That was, of course, corrected by Her Honour Judge Boucher granting permission out of time. So, in relation to Honour Judge Boucher's order, the appellant was never supposed to be before her. An oral hearing before Her Honour Judge Boucher cannot remedy the defect of not having an oral hearing in relation to the application to set aside the strikeout. The fair hearing, oral hearing authorities that I've cited support that, unless the appeal is an entire re-review. If you look at the whole merits once again, it doesn't satisfy Article 6. It appears from the opening paragraphs of Her Honour Judge Boucher's judgment that she was focusing solely on event 2. There were materials before her setting out the backstory in event 1 and how the listing hadn't taken place, but her judgment simply deals with event 2. Looking at it with a judicial review hat on, that raises the question of material considerations, whether a relevant consideration ought to have been taken into account. And then finally, she was materially influenced by the submission that the pleadings had not been served, and therefore the claim did not exist. Because she says at page 9, in fact it may be worth pulling up the
Transcript.
Thank you.
Okay, that's in 3, isn't it?
Yes, there are a large number of bundles in this page. Give my to and fro.
Oh, it's in 2.
So it's the second.
It's in 2. Sorry.
Thank you. I'm very grateful. And it's
Yeah.
the transcript begins in substance page
8.
9. And line 33 of page 9. She says, if we cut straight to the chase here and park everything that district judge, who's an extremely experienced district judge, did, the issue really is that this should have had an oral hearing argued before him. So she understood the point.
In exchange with Miss Longson down to line 30 on page 10,
Yes.
she talks about, you can see the way the court is leaning. At that point, she's leaning in favour of Dr. Alani.
Can I just
on
ask,
the
when she
extension
says
time point.
to Dr. Alani, you can sit down, Ms. Longswell goes in, was that because she was conducting the hearing with people sitting down? Or was it an instruction to Dr. Alani specifically to sit down when he was trying to make his submission?
I'm not sure.
I'm speaking only from memory, but I seem to remember that we were standing when making submissions because the courtroom that we were in was a very large one, and I recall Her Honour Judge Boucher seeming to be very far away from me. And it would be quite unusual to then sit down and be trying to project to a judge on a bench that was, I
Is
don't know whether
your
that accords with
recollection,
Dr. Alani's recollection.
My lords, I avoided taking you through the transcript because His Lordship told me that he observed
Yes.
how often I was interrupted. In fact, I was not given one opportunity to address the learned judge. Continuously, no, something about Disneyland and all.
That we can see,
Yes,
and we are very conscious of.
yes.
I just wanted, there was just this little
Yeah.
tweak at the bottom, so you sit down for a moment, Mr.
Yeah, she
Alani.
meant keep quiet. That's what she meant.
That's it.
Yeah.
Okay.
I was there. I can tell that from the tone, the body language. I was not wanted in that hearing. And I have never been in 20 years hearings in my life with treated like that. Thank you, my lord.
Well, now at the bottom of page 10, up to that point, the first 2 pages of transcript, on the question of extension of time, she's plainly with Dr. Alani.
Yes, and
And
subsequently
then Miss Longson refers to what she calls a slight difficulty.
yes. And
What do you want to say about the slight difficulty?
if one moves to page 17, there are the submissions as to service. And at line 25, Judge Boucher's capturing or attempting to capture the submissions before her and says, if I were to grant permission to appeal, then the case would have to remain struck out in any event because the proceedings have not been served on the correct party at the appropriate address because you failed to provide the court with proper information on the claim form.
Is that right?
No, not necessarily. And that's the point that I intend to bring to the court's attention because it's not necessarily the conclusion that the claim would have to remain struck out. It might do, but it might not. Because, well, there are 3 main issues. One is that a court considering this has various case management powers to retrospectively dispense with service. The court's familiar with the court's case powers, but to order service at an alternative address, that's relevant in this case because the address that the appellant used for service was Crown Prosecution Service 102 Petty France. That was defective in the sense that it ought to have been Government Legal Department 102 Petty France.
Should it not be Crown Prosecution Service care of legal GMD? Because
Not what
the box says defendants. Oh, it says defendant's address.
an address for service if
Can you just remind me
So
where
please, so you were in a minority. What's it called?
forgive me, my
Please.
lord, I missed that.
it's on page
Submissions.
72.
It's called Good Law Project. I'll just get it.
Defendant's name. It says defendant's name, and it's. Dr. Alani was not conscious of the obligation. That appears to be clear to mention GLD. But the box itself says defendant's name and address for service. So, which is why my suggestion would be that the absolutely best way of doing it. I was going to say foolproof, but that may not be the satisfactory thing. Would be to say Crown Prosecution Service of Government Legal Department.
Perhaps, but I think it matters not for the court's purposes because the point that I'm only seeking to make is there were case management options open to a judge considering service to disapply, to extend time, all sorts.
So you said yes.
So your first one was retrospectively dispense. Second one is extend time.
Alternative place So a court can say, so this is 6.5 of the Civil Procedure Rules. Court can say, I retrospectively grant permission for you to serve it at Crown Prosecution Service 102 Petty France.
CPR what is that? 6.5.
6.5 subsection 2.
Is it recent undergo, is it?
So that's my sort of heading number 1. The court had case management powers to consider. Whether or not it would have exercised them in the appellant's favour is a different matter.
But which we can't go into.
No, and secondly, challenging jurisdiction has to be done by way of CPR Part 11. So the filing of an acknowledgement of service followed by which ticks I intend to contest jurisdiction.
So just say that again. Sorry, I was checking that.
That's all right. The second point is that contesting jurisdiction doesn't have to be territorial, it can be otherwise, has to take place through the procedure in CPR Part 11.
Yeah.
And in summary, one must file an acknowledgement of service saying, I intend to contest jurisdiction. And then within 14 days, there's an application to contest jurisdiction. The authority for that is Hodinot. It's in the authorities bundle tab 3.
Yeah.
And what that, without, forgive me, I'm trying to take things briefly, but pause me if it's necessary. That judgment in effect says, just because you can strike out, you can bring an application to strike out, that's not a means of circumventing Part 11.
Have you got a paragraph? Don't take Stuart, but have you got a paragraph number? Or you've put the paragraph number in your written submissions.
No, I won't have done because all of this about service came to light after that. So I have page 38, and I've sidelined page 46, paragraph 25 onwards.
Thank you.
My lord, if it helps, it is in my skeleton argument what paragraph of the.
I knew I'd seen it somewhere. Thank you
Yes,
very much.
it's actually, I think I can tell you where it is at the moment.
2022 355.
25 and following.
It's in the authority bundle as page 448 GH.
Thank you.
That's the Hodinot authority.
Thank you very much.
Thank you.
A court considering the issue of service may also have regard to CPR 7.7, which is the ability of a defendant or an intended defendant to apply to the court to ask it to make an order that it be served with the proceedings. So where a defendant is aware of proceedings and wants to put in some sort of response.
CPR 7.7, is it?
Yes.
Thank you.
These are options. I'm sure there are more that I've missed. They may have all been rejected by a judge considering them.
Yeah.
But
And they may become relevant when the 3rd of March
yes,
is finally heard.
yes. And it may be that none of them succeed. The third sort of limb or argument in relation to service is that it is possible to have waived at common law any objection to jurisdiction by conduct. It's a very fact-specific argument looking at what correspondence, etc., would have involved. That was raised by Dr. Alani in his judicial review statement of facts and grounds, paragraph 51. I should make it plain that all of those 3 legal arguments that I've raised were not raised before Her Honour Judge Boucher. I should make that plain. The court earlier has made remarks about notice, etc. That's plainly a matter for the court to consider. But my overarching point is that, with great respect to Ms. Longson, I'm sure it was inadvertent, but it is wrong in law to say this claim would have to remain struck out. And in fact, I say that I'm not even sure that I'm quoting from Her Honour Judge Boucher's summary of Ms. Longson. So it may be that Ms. Longson didn't say that per se. it's not a criticism of Snongston. The point is, Her Honour Judge Boucher appears to have been influenced in not ordering an oral hearing by the service point. The service point effectively being a concrete one that had no way around it, and that would be an error of law.
This was where a judge struck out a claim, his own motion. Whether the claim had been served or not was irrelevant at that stage.
Well,
You have a claim that hasn't been served. It doesn't mean you strike it out.
I'm just thinking through matters, my lord. The Her Honour Judge Boucher was considering the strikeout by event 2. So the concept is, the thrust of your argument is that you should have had an oral hearing. However, because of case management, etc., it's going to remain struck out because this is the eventual outcome in any event.
But what I just cannot understand at the moment is how the fact that there may have been an argument that the claim had not been properly served in any way affected the right to apply to set aside the striking out.
My lord, I would submit that it is likely that those sort of considerations may be relevant to whether or not the court should set aside the order. However, and I say that I can certainly imagine an instance in which a county court is saying, well, should I allow the appeal, or is there not going to be any substantive difference? But I come back to, I may be right or wrong about that, quite frankly, but I come back to Lord Newburger in Le Bruche saying you can make robust decisions, that's to be encouraged, not at the expense of an oral hearing.
But the way it should work,
Yes.
is where he's entitled to his oral hearing, full stop, end of story. At the oral hearing, it would have been open to the CPS, had they done it properly, to say these proceedings have not been served on us. If proper notice had been given of that, then the way to respond to it in a sort of orderly way is to say, well, in that case, I apply either for retrospective or dispensing service, or to amend the claim form and serve within 14 days. And then, in that context, the CPS might say, well, no, you shouldn't do that for 47 different reasons. Yes. And in that context, it can become entirely relevant to whether the end result of the oral hearing is that the claim stays struck out or not.
Yes.
But the starting point is not in doubt, which is they're entitled to make that they're entitled to apply for summary judgment against someone who had not acknowledged service.
Yes, and if one considers the same legal test that this court is considering in terms of is the appeal made out, whether are there grounds to show that the judge was wrong in law, or it was otherwise unjust, well, the court may think it's arguable that there was an injustice by virtue of the lack of an oral hearing.
And, I mean, I'm not completely on top of this, but I know from my Lord Justice Phillips that he has been involved in a decision of the Court of Appeal, including, I think, Lady Justice Clara, she then was, where a very, very strict view was taken on a failure to serve properly. So he knows all about it, I don't.
But the Queen Good Law Project and the Secretary for Health and Social Care.
Thanks so much.
2022 EWCA Civ 355.
You're just showing off.
My Lord and I had actually got it up
Anyway,
in front of us.
But the reason why I'm raising it with you is to just put a bit of additional colour onto your submission that there are various ways it could happen, and there are various ways in which if it was held to be a failure to serve properly, could be dealt with.
Yes, and that's where I made reference to the court's case management powers. Those are the powers that a court would use to extend time, retrospectively dispense with, etc. Now, the CPS's defendant might have very properly said, well, actually, we would like you to make an order that we are given more time to put in an acknowledgement of service and are contesting the jurisdiction application. So, as I say, these matters may not have necessarily gone in the appellant's favour. I make no comment on that.
So drawing these threads together, and this is not a criticism of Ms. Long, who's raised what she described as a slight difficulty, and we've all read what happened after that. That this was a point which was not of which Dr. Alani had no, and his client had no notice. It was raised without the formalities having been complied, any formalities having been complied with, and the judge's conclusion that it was the definitive answer was wrong.
Yes,
You accept all that.
it's the third point that I would like to really make in my submissions. That again, going back to the administrative court, divisional court's viewpoint, was the decision affected by a material error of law?
Okay.
Because that
Not
is
a
what.
conclusive answer.
Forgive me, my lord.
It was not a conclusive. I'm mumbling. Not a conclusive answer. Therefore, the judge made a material error of law.
Well, that's a matter for you.
That would be a way of looking at it.
Yes, because these are judicial review proceedings.
Yes.
So, an administrative or divisional court would not even need to say that something went wrong, or this should have happened, or remake the decision. It's was there an error of law? Did it have a material impact on the decision? It might be that it didn't, but
Right.
these are all matters for the court.
Thank you.
Ms. Longson did make one rather bold submission at page 12 of the bundle for the transcript, line 12. The case does not exist.
I'm prepared to accept that I misspoke. I came on later to deal with the CPR 11 point,
You
the
did.
acknowledgement of service point, and I was alive to that.
Yeah.
And you may have got the impression from this transcript that this was something of a fraught hearing, and I'm perfectly prepared to accept that I misspoke.
That's very good of you. Thank you.
Now, Ms. Milligan, what else do you want to say about the hearing, which is
Nothing, my lord. That brings me to the end of.
that's 3, now 4, which is what
4
next?
is what next, but as I said, I
Right.
anticipated we were likely to have covered that. And so I'm not sure that in the absence of any assistance that the court requires, I really need to trouble you with that. The court will of course be alive to, and I think I can say this, the court is concerned about the cost and the delay of simply going through the judicial review motion. So if I can assist in any way, please let me know, but otherwise I will probably leave it there for today.
Just on that note,
We weren't proposing to ask you to say anything, given your status here as a nota.
Yes. I don't have anything to say, only to clarify in relation to my friend Miss Milligan's submission about whether I had invited the judge to conclude that the right course of action would be strike out on the service point alone. I didn't suggest to her that the correct order would be strike out on the service point alone. I think the reason that Y's have been crossed is because she was determining whether the matter ought to remain struck out as a result of the service point, rather than me having suggesting to her that I would have applied for strike out on the service point alone. I've articulated that horribly, so please let me know if you want me to clarify it.
Thank you. Now, Dr. Alani, you have a right of reply.
I must start by thanking your lordship for being so kind to allow me to address you, which is something I haven't had throughout these proceedings, either before, I must be honest, either before Her Honour Judge Bosher, nor before the Deputy High Court Judge. I don't know how you feel, your lordships, about the competent submission of learned counsel, but for me it was very exhausting to follow, I must say. And I would like to point out a couple of points which I think I managed to grasp, not everything, but
Just give me a moment, would you? Just, I don't have a word. How long do you think you're going to be?
10 minutes?
Well, should we carry on? We're coming up to 1 o'clock, but should we finish now before the adjournment?
I can finish before the adjournment.
Thank you very much.
Yes, yes.
Yes, let's
Won't
do
take
that.
long. Won't take long. And there's a question of, I think, learned counsel referred to the matter of vacating the hearing, which I think is very significant, and I think his lordship pointed that out, saying who did. I think counsel said it's a clerk of the court. I take issue with that. I think vacating hearings are not functions of the clerks. They are usually
Judicial decision. Is that
absolutely.
Yeah.
And I would like to point out why I come to that conclusion. It's because of the judgment of His Honor Judge Latham, and I take you to page 92 of the first bundle. My lord, this is his order of the 15th of 8 November.
Yes, I think I've got it the 12th actually. 12th of November.
Yes,
Oh, it says 15th at the top.
yes,
You're
it is.
right.
It is 15th, my lord. That's
Sorry,
page
my
90.
mistake.
Paragraph 1, and this is how upset learned judge was. He said, the appellant maintains that the court wrongly refused to issue an application filed on or about 7th of May, which learned counsel referred to you to. If this is correct, then his remedy was judicial review of the refusal to issue the application. We've always been told that judicial review should be the last resort, and whenever there is an alternative remedy to be pursued. I don't know why the judge wanted us to go for judicial review. Sorry to interrupt. I continue. The balance of section 11 makes no sense. That's a section 11 in the submission. There is a suggestion, this is the part that matters. There's a suggestion that district judge Event refused the application notice. That could not be right, as the appellant's notice is case managed by a circuit judge and would not be open to the district judge Event to grant or refuse the permission. His Honor is saying that even a case management in the case is not in the hand of a district judge. How could vacating a case of which he was seized could have been done by an employee of the court? The second matter, which I think is very important, another failure of the court, is that following the instructions of the court on the 16th of June, that it was not possible to issue the appellant notice, I applied for the appellant notice to challenge that order on the 25th of June. The court advised me that this was not allowed, which led into a delay of few months, which itself forced me to apply for extension of time, which made Judge Latham refuse it as being woefully out of time. The failure was completely the court, because the application on the 25th of June was a proper application under the authority of Anwar. And my learned friend took you to the authority, but I would like you to look at the ratio. This case is at page 224 of the authority bundles, the 600-page bundle.
It's also, I think, in Miss Milligan's bundle too.
No, I'm just referring to the ratio of the case
In the head note.
Yes, sir. Yes, my lord. Yes.
Yes.
Yes, and that tells it all without having to go through I appreciate what Learned Counsel did, taking through several paragraphs, but it's basically in that head note tells you what the judgment is. The application of the 25th of June was proper, and the court was wrong in having refused it, which led to the application and the delay and the refusal of the circuit judge. I think I don't have. I think that's all, my lords. Thank you very much for.
Well, thank you very much, Dr. Alani, for your submissions in this case. We're grateful to all of you for coming today and for your help. We're going to reserve judgment. Ms. Milligan, when do you think you'll be able to supply us with the note? You may have heard me suggest to Lord Justice Stuart-Smith that Monday might be appropriate. Is that okay? Too soon.
Let me just
7 days?
check my
We're
professional.
listed for a day today.
So I ought to spend this
Could
afternoon
you?
doing it.
I mean, we're not asking for anything very grand. You told us it. If you just an email
Yes,
with bullet points and the references is all we want. Just so.
yes. I'll aim to have it with you this afternoon. It may be by Monday, but I'll certainly.
Well, I'm going to say by Monday, if that's possible. Thank you
Yes.
very much.
My lord, I have prepared a list in which the authorities referenced in the bundle are cited. Would you like a copy of that? Would it help you to see which authority appears where in the authorities bundle?
Yes, please. Thank you. Could you send a
I will email that
copy?
to you.
Thank you very much.
Thank you, my lord.
So we're going to reserve our judgments. In due course, we will send out a draft judgment to counsel in the normal way. That is to provide you with an opportunity for drawing our attention to any typographical errors or minor factual errors. It's not an opportunity, of course, to re-argue the case. The draft is sent out subject to an embargo, as recorded at the top. Please bear that in mind. It should not be disclosed to any unauthorized person. Any such disclosure would, of course, be a contempt of court. When we send out our draft and when you send back your typographical and other corrections, could you try to agree an order which reflects what our decision is in the judgment? Any issues between you as to subsidiary or ancillary matters will be resolved on paper, and if there are any such issues, we will get short written submissions on the points in dispute.
Just so as to enable them to engage with the order, should we say that we'll send the draft to the CPS or the draft can be shown to the CPS?
Yes. In this instance, it's for any avoidance of any doubt, the draft will be able to show the draft to the CPS, and we'll send it to you, Miss Longson, as well, and so it can be shared with the CPS, even though you're not a party to the appeal.
No, and do I understand from that that is with a view ultimately to the CPS giving the indications that you referred to right at the beginning of this hearing in relation to your proposed?
I think we haven't. I think we haven't discussed this, but
No.
which we will now go and do. But I think there are two possibilities. One is we'll proceed straight to a judgment.
Yes.
The other is we will do the thing that I think I suggested halfway through the hearing, which is to give a direction or something saying this is what we're minded to do. Does the CPS wish to make submissions? But there's no undertakings about which way we're going to go.
No, of course not. I just want to make sure that I'm not missing any obligation on my client to do anything now, and we are essentially awaiting further.
There's no obligation.
order or
There's
direction
no obligation on your
from the
clients to do anything now. It may well be that we will invite the CPS to take certain steps in due course, but we
Yes.
haven't discussed that yet.
That was my
So
understanding.
So you will be included in the
Correct.
disclosure of the judgment,
Thank you.
and the right to disclose. You have a right to disclose it to the CPS
Yes. And take it
for that and other purposes. All right.
I think you normally submit a list of people to whom it may be disclosed. So you will need, if you haven't done so already, you'll need to supply a list of who at GLD or whatever it's going to go to.
It may be that my instructing solicitor has already done
I
that.
didn't see that. Have you seen the list? No.
perhaps I could wait behind and find out if somebody's able to look, a member of administrative staff's able to look at the court
Well, I'm not sure
file,
that will
because
be.
I don't-
I'm not sure. Would your clerk want to do this?
Yeah.
My Lord Justice Stuart-Smith's clerk will be in touch with you to just make sure that we've got the full details.
I'm very grateful.
Thank
My
you.
lord, and one last point, if I may. What about the question of cost? Would your lordship be considering the cost of this hearing?
That is one of the ancillary issues to which I referred.
Thank you. Very
That's
much
one of the issues which you should endeavour to agree when you see our draft judgment. If you're not able to agree, then short written submissions from the parties, please, in writing, and we'll make a decision on.
Grateful, my lord. Grateful.
Thank you. Thank you all very much.